We have a real attorney who's going to explain the Duke versus Darian Mensah lawsuit next here on the College Huddle. Welcome into the College Huddle, everybody. 87 independent podcast from coast to coast. Hey, go check out the website, thecollegehuddle.com, where you can find your favorite next podcast in college sports. We would love for you to do that. We would also love for you to go ahead and hit that thumbs up button. And we'd love to have you subscribe to the channel. Thank you to so many of you who have subscribed in the past couple weeks. We really do appreciate that. We bring you daily football, college football content right here on the College Huddle. And today's episode is a very special one. I interviewed Ben, a real life attorney from the state of North Carolina, happens to be a Duke fan, and he broke down the Duke versus Darian Mensah lawsuit for us on my other channel. It was so good, I had to bring it here. I put together 3 clips of him answering a couple questions from myself and my colleagues about it. And then after he's done with those, after the clip, I'm going to come back, give you my 2 cents. You're going to love this. If you're a college football fan at all, this is probably possibly one of the biggest landmark lawsuits that could change the sport, and it's widely ignored right now. So I hope you enjoyed this. If you're a Duke fan, I think you're really going to love this. If you're a college football fan, I think you're going to find this intriguing. Make sure you grab your popcorn. It's very entertaining, and even maybe a legal notepad, because you might want to take some notes. Here's the interview.
Essentially, and we're using the term contract, which is what this is. It's technically a licensing agreement. So think about stadium name deals, right? Where it's, M&T Bank Stadium, or, the Panthers used to be Ericsson Field or Ericsson Stadium, right? It's an agreement whereby company X leases the right to, or the Panthers lease, or whoever leases the naming rights to the stadium to a company in return for money. That's essentially what you have here. Is Mensah is coming here. He is being paid money so that Duke can use and license his name, image, and likeness for this 2-year period. Okay. One of the things that you talked about, coming to school and all that stuff, there is a clause in there that separates this from any scholarship and financial aid requirements. So we need to be careful about that, because this agreement is not tied to performance on the field, one, but also it is not something that is tied into the complicated issues with higher education law, FERPA. I'm not going to get into that. I'm not an expert in that. But you're essentially correct. All right. So it's a 2-year deal, a 2-year licensing agreement. And essentially what happened was this. This is a pretty well drafted complaint by Duke's lawyers. And if you look at it, you'll see that Nina King signed it. I would not read anything into that. Like, don't think, oh, she's pissed off, this is why she signed it. That's not what's at play here. This is what's called a verified complaint, in which injunctive relief is being asked for. When you are asking for injunctive relief, you have to file a verified complaint in most jurisdictions. You have to do it in Virginia. We've done it before at our firm, and apparently that's what you have to do here. She signed it, I would assume, because she's the one who signed all these other licensing agreements and is the athletic director. She just happens to be the natural person to sign it. Okay. When we're talking about injunctive relief, there are a couple of things that are being asked for. Court systems in America have generally two types of powers to grant relief. One is legal claims, so claims for money damages. The other is non-monetary damages, or equitable relief. An injunction as a non-monetary damage, or non-monetary remedy, is a form of equitable relief. Okay. That's what they're coming to ask for right now. And primarily what Duke, they meaning Duke, what Duke is asking for is to compel arbitration under the licensing agreement. Okay. There is an arbitration clause in the licensing agreement, and Duke has said, hey, please order this to go to arbitration. We need a temporary restraining order against Mensah, which sounds really, really bad, but it's not really that big of a deal, to stop him from leaving the program. And this is what's important: continuing to breach the confidentiality clause of this licensing agreement, because there is a confidentiality clause in there. That is very artfully laid out in the complaint for injunctive relief. Okay. That's important, because what Duke is saying is we do not want this information getting out there. We don't want our trade secrets getting out there. We don't want to, just for example, you don't want to get your secret sauce handed out to your competition, right?
Mm-hmm.
That's what is the most important part about this. Okay. So essentially, that is what Duke has asked for, is to make sure A, this goes to arbitration, and B, that he doesn't leave the school while there's a request to have it arbitrated and the matter is being arbitrated. Now, once that happens, everything after that's going to be secret. Arbitration will gobble it all up. It's going to be secret. And I think that's what will happen. And let me indulge you for just a few more minutes.
Sure.
All right. In litigation, it is a marathon. It's not a sprint. We are at the very beginning stage. There's been a request for a temporary restraining order. There was some muddled reporting. I don't want to say the Heitner guy was inaccurate about it. He wasn't wrong with what he set out, but it didn't, what he set out and what he put in the Twitter narrative. But essentially, it sounded like Duke lost completely its request for a restraining order. And that's not what happened. Duke got actually very broad relief initially at the temporary stage, and we can get into that in a minute. But a temporary restraining order is somebody who has gotten protective orders and defended against protective orders before. They're very easy to get. The preliminary one is very easy to get. They are much harder to extend and make permanent. Okay. So that's what this hearing on February 2nd is going to be about, is do we make this relief permanent? I think obviously it's going to go to arbitration. I don't think there's any dispute about that. The other matter of can Mensah go to another school, that's going to be more complex. But what Duke did get, and this is an absolute victory for Duke, you cannot spin this any other way, okay? I'm pulling up the order right now. This is paragraph 2 of the ordered relief. For the duration of this order, defendant Mensah and his agents, employees, attorneys, and all persons acting in concert or participation with him, with his knowledge, or under his actual or apparent authority, are enjoined from enrolling at another collegiate institution, playing football at another collegiate institution, licensing his NIL to another collegiate institution, taking any other action that would interfere with, diminish, or impair Duke University's exclusive rights under the contract, and otherwise committing any further breaches of the terms and conditions of this contract. He can enter the portal, but he can't do the other stuff, which is primarily breaching the confidentiality clause, which I think we know pretty clearly happened, because if you look at the complaint, and let me go back to the beginning of it here, there's a very good timeline that Duke's lawyers put out there. Okay. You look at paragraph 30 at 2:07 p.m. Eastern on Friday, January 16, 2026, sports media begins to report, hey, Mensah's going to leave Duke. Here are the terms about a potential buyout. And they have a screenshot on Twitter. Then almost 2 hours later, Mensah's telling Manny Diaz, hey, I'm entering the portal. So Duke has established a breach is occurring. They've shut that down now. That can't go on. Okay. That's a big, big win for Duke. Huge win for Duke. But we'll see what else happens when it goes to the hearing on February 2nd.
So, in layman terms, they had a 2-year contract. This is about his NIL, name, image, likeness. He can go play wherever he wants, but he can't take money for his name, image, likeness, because that belongs to Duke for 2 years.
If this agreement's enforceable, correct. Well, it'll apply until, I believe, the end date of the licensing agreement, which is December 31, 2026. That's correct.
Okay, Chris, you're next, man. Go for it.
All right, so we've talked about Mensa, but is there anything here that is legally actionable against Miami as well for their participation? Because obviously, given the timeline, it is, you can conclude that there was tampering which occurred. So is there any actionable legal action to be taken against Miami as well as against Mensah?
That's a really good question. I'm going to defer this a little bit here, and I'm going to refer you all to David McKenzie, who is a lawyer in North Carolina. If you've listened to the Ovius and Giglio podcast, you've heard him on. He is fantastic. Okay. He deals with this kind of stuff all the time. Apparently, and I've talked to another North Carolina attorney friend of mine, he has told me this could be a real issue, okay, coming up for Miami and potentially Mensah as well, although we'll have to see. But essentially, there is a provision under North Carolina law. I'm trying to pull up the name of it that Duke could use against Miami that potentially could allow Duke to get a whole lot of money from Miami over this. Okay, what? Oh yeah, here it is. It's the North Carolina Unfair and Deceptive Trade Practices Act, which has an escalating damages provision. Apparently, it can triple the damages. Now, how you prove that? Little difficult here. I think Duke would probably put some evidence about what they weren't able to do, what they get, and the money apparently, and this is kind of all going to come out at some point, but money that went to Mensah that could have otherwise been used on defensive players last year, maybe keep Queso Brown. And of course, now you're going to lose Cooper Barkay too, which is a huge loss. I think he's gone. So the way that the case against Miami will come out, because Duke sidestepped all that in the complaint filed against Mensah, which was smart, there's going to be some discovery in that arbitration proceeding because they've said, hey, Mensah's breaching his contract. We need documents, emails, what have you, from Mensah, text messages, phone access to some extent, whatever, of his phone, his emails, texts, to show who he was communicating with. These details got out. And apparently got to Miami if this reporting is accurate, right?
Right.
So there could be a case against Miami under North Carolina state law, the specifics of which I'm going to punt, okay, because I'm not licensed there and I don't do that type of work. But if McKenzie's right and if my other colleague is correct in what he said, yeah, there could be a serious action against Miami here.
Now, you mentioned, and obviously this is something being fought in the state courts right now. Is this something that you could see going to federal court at some point?
Not as things currently stand as far as Duke versus Mensah, because Mensah is a resident of North Carolina, according to this licensing agreement and the pleadings. So you would not have what's called diversity jurisdiction, where the parties are residents, citizens of a different state, to bring them in there. And does not appear to be any federal law. If there's also federal question jurisdiction, so if some of the claims arise under federal law and give rise to a federal question, the federal courts in North Carolina could exercise jurisdiction over this. If this gets appealed all the way to the Supreme Court, it would have to go there from the North Carolina State Supreme Court, then to the United States Supreme Court. That would be the only way. But Duke versus Miami would have to end up in federal court unless there's some agreement that the schools have as part of being in the ACC, where they have a choice of forum provision. So, no, this would not end up in federal court as of yet. It would be a long slog to get there unless you get other players involved who are not currently involved.
Gotcha.
TG?
I would ask, do you think that this lawsuit might end up turning players, college football players, into classifying them as employees?
So that is one of my long-standing gripes about this whole thing. That's what should happen, right? And I think there's a number of reasons that the students are not employees, that these players are not employees. One, the workers' compensation payouts for some of these guys would be huge for career-ending injuries. All right, and then you're dealing with week-to-week kind of compensation you could get, and going to a panel of doctors. There's a lot there that I'm sure administrators want to avoid. There's also union issues, particularly with the southern schools, that definitely want to be avoided. These southern schools do not want players unionizing and forming public sector unions. This agreement is not the kind of employment contract you would see. There's no indicia of control. There's no control over the means, manner, and method of any work he's supposed to do. It's just an exchange of name, image, and license rights. Okay, so those issues aren't at play here. But your point in your question is a good one, because what's really underlying all of this is a workaround, an employment framework that the NCAA will not let people do, right? And the thing that I don't understand here is why you just can't make these guys employees, because with the amount of money that you're paying these people, and we can get into a whole lot of discussions about when you start treating these students, these young men, as professionals, right? You're getting paid $4 million a year. If you do it in the NFL, it's for a period of time. Either it's a 1-year agreement or a 2-year, multi-year deal, what have you, okay? There is no reason that these schools paying this much money to these young men should not be able to treat them like employees, and there's no reason that the young men should not get the rights that the employees would get, right? There's no reason not to have those rights. None at all. But if you employ them, then you can have these things called non-competes, okay? You can put in, you cannot go to a conference member school or a common opponent school, right? You need this stuff if you're trying to build a program and have some stability around it. I mean, as a fan, it's impossible to keep up with this stuff. If you're at a school like Duke that historically has not done well, right? You need to be able to have something that's going to keep your guys there, and let's get these. You can have non-competes, and it's not unfair.
Thank you, Ben. Appreciate so much you joining us and breaking this down for us. Now, there's a couple things I'd like to talk about here at the end of this video for all of you to kind of think about. Number one, and Ben went on to explain a lot more in the hour plus that we had him on my other channel. And one of the things that came out of this is that, in a nutshell, in a nutshell, um, Mensah can go on to play at Miami. Even if Duke wins this lawsuit, he still can go on and play there. But Miami's going to end up owing Duke, and Mensah's going to end up owing Duke a lot of money. So that's the first thing. The second part to this that is incredibly interesting and probably not a good thing is that agents and agencies who represent these college athletes all across the country are really watching this closely because Mensah had a 2-year contract with Duke. If that contract um, is found to be accurate and held up in the court of law, do not look for agents to have their student athletes signing more than 1-year deals when it comes to their NIL with universities. A lot of people have been saying, man, we need to sign these guys to 2 or 3-year deals. That's probably not going to be happening moving forward unless you're just willing to drop a absolute ton of money on these kids' laps to where the agent says, yeah, you better take this. Reason being is there's these situations where if you have a good year and you were making 4 and someone wants to double your salary, you don't want to put yourself in a situation where you could have made 8 the next year instead of just making 4 again. So agencies are not going to be wanting to play that role. And then the third thing is this the beginning steps of seeing college football players become um, employees of the universities? Um, I think yes, it is. Ben tended to think maybe not. The universities didn't want that to happen. Um, it's going to be very interesting where this goes because I think it's very divided on that topic of it. Either way, incredible interview. Thank you again so much, Ben. Really appreciate it. Your time, all of your expertise. Love to know your thoughts down in the comment section below. This is a very interesting topic, and I'm sure that a lot of people are going to have a very wide range of opinions when it comes to this particular story. Let me know your thoughts down below. Let's have a great discussion. Enjoy the rest of your Friday. Have a great weekend. We'll be back with more college football content and videos right here on the College Huddle.